friends, let me welcome you to another San Diego County Medical Society webinar. This one, again, partnered with the Doctors Company. We started this series, I think just a few months ago in June, and it has been really popular with members so far. We think it's a great opportunity to have engagement and get some important information out to physicians in our community, and really appreciate all the work that TDC has done with us, particularly offering CME credits and hopefully making it more valuable for your time in the different programming that we're doing. One of the things that I was instructed to ask, I think smartly by Kathleen, was to ask you for different topics and different other webinars that you would like to see as we're planning our 2022 calendar. I'd love to hear back from you about different things that you think would be important or interesting for us to cover in the future. So with that, I'm going to introduce Kathleen Stillwell.
Thank you, Paul. Good evening and welcome to our program tonight, Understanding the Risks, How to Dismiss a Patient from Your Practice. We'll get into that, but I would like to first tell you that if you would like to be claiming CME credit for the program tonight, if you have a smartphone, if you take it out now and put it on camera and hold it up to the QR square, it'll show a pop-up will say tap here, and you tap and it'll take you to this screen, which will ask you for your first name, your last name, your license, which is an MD or a DO. If we have any PAs or NPs attending, the PA board and the Board of Nursing will accept the credit for tonight's 1.5 CME credits will be comparable to 1.5 continuing education credits. Your affiliation is the name of your group, or if you're not in a group and you're just attending, just put your name again or whatever you like. The certificates are sent out within 7 to 10 days. However, my assistant, Julianne Miles, she's so on it. I'll bet you'll get the certificates tomorrow. You do have until 5 p.m. on November 24th to get the credit. And if you need any assistance, the phone number is here and Julianne can walk you through it. If you don't have a smartphone and you want to go on the computer, you can do that and go to doctors.cnf.io and follow these instructions on this slide. And the slides are available, I believe, I don't know if they were sent out, but Jen has the slides. So this topic is a really hot topic right now because with the COVID climate that we've been in now for over 20 months, the disgruntled, unhappy, complaining, and pushy, bullying patients have gotten on everyone's nerve, your staff and the physician. And one of the first reactions is often just, let's just get them out of the practice. But that has to be a last resort. And so tonight you're going to hear about why it's a last resort. I need to share our accreditation disclosure that there is myself and my colleagues speaking tonight have signed that we have no disclosure and no conflict of interest. My name is Kathleen Stillwell. I'm the Senior Patient Safety Risk Manager with the Doctors Company. I won't go through my whole bio here because it would take too much time, but I've been in risk management in healthcare for over 38 years in many areas. I've been with the Doctors Company for the last 14 years, and my favorite part of the work that I do with the Doctors Company is creating programs, delivering them to you. And of course, we don't do anything in person now, but we do everything by webinar because of COVID. And I anticipate we're going to see more and more because our reach is so much higher when you don't have to get in the car and drive somewhere. With me tonight is Richard Cahill. He is our Vice President and Associate General Counsel. He's my favorite person in the company. I try to do all my programs with him. He's amazing. He received his undergraduate degree from UCLA and his law degree from Notre Dame. And he has been so instrumental in supporting the patient safety department nationally. He also has served as a deputy district attorney in California and was staff counsel on the Nevada Supreme Court before entering private practice in Southern California. He has been over 35 years in healthcare litigation, primarily in malpractice, for the defense of hospitals, physician liability claims, managed care. He has had principal clients including Cigna Health Plans, Kaiser Permanente, and Tenet Health. He has an extraordinary background. He's also sees all of the appellate litigation for the doctor's company. He researches and writes original content from our publications, and he is a frequent lecturer all over the country, and I'm very pleased he's here, especially because he starts work at 3 in the morning and ends about 1:30 because he serves the whole country. So it's past his bedtime, and I really appreciate that Rich is with us tonight. I always like to start with something that's a bit of an inspiration to get us on the same page. It's the end of the day, you've worked late, so sit back, take a deep breath, and remember what the Dalai Lama said. Do not let the behavior of others destroy our inner peace. And this is not just with our patients and staff, but people in our lives. You know, we have to put ourselves in a bubble sometimes to get through the day. Our objectives tonight are to educate you regarding reasons a physician may need to consider dismissal of a patient, how you would develop an action plan in case you need to dismiss a hospitalized patient, and assess your practice for opportunities to improve and actually decrease the potential need for dismissing a patient. So why are we talking about this? Well, disruptive patients are a problem. And you also, as an employer, have a responsibility to your employees to protect them from a hostile work environment. So patients who are disruptive, inappropriate, use foul language, do name calling, bully, whether it's on the phone or in person, that could be construed by an employee that they're working in a hostile work environment, and the employer is required to do something about it. And the do something about it isn't just to get the patient out of the practice. There's also training for your staff on how do you handle this? What do you say when someone says something inappropriate, and what do you do? And we offer that kind of training for staff. We do that also, of course, by webinar now, because we don't go out, but that is available. So you have communication issues, disruptive patients, and sometimes it's their family or someone who comes with a patient who's the disruptor, but that can really compromise what you're trying to accomplish with the patient. It also can have a negative effect on the patient experience. And I will tell you, if you're sitting in a waiting room, if I'm sitting in a waiting room and I'm observing at the front desk that a patient has come in and is being rude and inappropriate to the young lady or the young man at the front desk, I'm sitting there thinking, why isn't anybody stopping this? Why isn't somebody putting a stop to this? Someone needs to get the office manager to come, get that person out of that front office and take them aside and said, I'm sorry, you know, we have a zero tolerance for that kind of language and that kind of behavior in the office. And, you know, we can't accept that. So disruptive patients can adversely affect your business and your brand and the relationship building that you want to be successful. So I call these patients red flag patients. So you know who they are. They're the people who come with unrealistic expectations. They might be hostile, angry, and demanding, and just unhappy. They may be non-compliant patients. And sometimes they're very good at the beginning. They even come with a box of candy or something for the staff, but then, you know, their true colors come out. And one of the things that we know is that sometimes people are having a bad day and they might be on the phone or in person be inappropriate. So is it a pattern? And one of the things that's important to train your staff is we need to document inappropriate comments in quotation marks in the medical record, because you're going to hear tonight that without that kind of documentation, if you're dealing with an HMO, with a managed care network, you're not going to be able to get their approval to dismiss a patient unless you can show them 3 documentation of inappropriate behavior, inappropriate language. So we'll get into more of that as we go forward. There's also an ethical obligation, and that is that the state and the federal laws prevent you from terminating patients during an acute phase of treatment. So that means if I come to you and you've done a procedure and then you say, Kathleen, I need you to come back for a checkup in a week or 2 weeks, until I'm sort of through that process in permanent and stationary, you can't dismiss me. Now, what you can do is say, you're not going to see me. And if you have another physician in the practice, you can say your colleague will see me. If you have a PA or an NP, you can have them provide the follow-up care. You may not terminate the patient if their post-op or post-procedure visits have not been completed. And that's important to understand because that is considered and it will fall under the prohibition of discrimination for patients. The Code of Ethics that the Medical Association, the American Medical Association, published this in 1847. I just thought that was kind of a cool look at the picture of the book. And this is what it says, that they last updated it in 2016. When considering withdrawing from a case, the physician must notify the patient or authorized decision maker long enough in advance to permit the patient to secure another physician and facilitate transfer of care when appropriate. I'm going to tell you what it doesn't say. For the physicians who think, or the patients say, you have to give me a referral. If you're dismissing me, you have to give me another name, or you have to give me 3 names to pick from. No, in fact, at the doctor's company, we say, please do not give anybody a referral. First of all, if you do, then your colleagues will not be happy that you send your problem patients to them. So what you want to say is check with your health plan network or check with the local medical society in San Diego County. And you, I'm sure, have a referral line or a referral process. They usually do, but you do not want to say, go to this doctor or here's 3 names, pick one of these. The other thing is the doctor's company follows the California Medical Association guidance, which is very specific about how much time you have to give. And it's recommended that you give no less than 15 days and no more than 30. And it says I will be available for blank days, 15 or 30, for an emergency. And so an emergency, if they have an emergency, tell them to go to the emergency room. So what we're really saying is we don't want them coming back, but we just say I'll be available for an emergency. Also, the CMA says if you're a specialist, you can dismiss with the date of the letter. The date of this letter, as a specialist, I am dismissing you the date of this letter. That's a little bit tough on patients. And we'll talk a little bit more about if they need prescriptions and so forth, you can prescribe in that dismissal letter. I'm providing you with a 60 or 90-day prescription of 1, 2, 3 prescriptions, because once that termination date comes and goes, you cannot prescribe or refill after that date, or you null and void the dismissal. You'll hear more about that. Potential wrongful termination risks. Terminating a patient without following the requisite rules to this that you're going to hear tonight. A patient can claim abandonment. They'll say you failed to treat me, and they love to run to the medical board and complain. They can use charges of elder abuse or neglect, breach of contract with the facility, and it could be with the facility or a contract you have, for instance, with an IPA or with an HMO or with a health plan network. They can say it was care beneath the standard of care, and it falls under allegations of unprofessional conduct with the medical board licensure. Termination of the patients really presents many challenges for you because of contractual obligations. So that has to be looked at. And a policy or procedure for managing disruptive patients is important. I will tell you that personally, and I think Rich, our attorney, is here, he would agree with me on this. You want to be very careful about having policies in your practice, because a policy will be called in a litigation. It will become part of the discovery. We'll say we want your policy on patient termination. You can have a procedure for termination, which isn't a policy, because here's what happens. If you have a policy you don't follow 100% of the time, and then you get in a litigation and that policy is brought into the discovery and you didn't follow it, you're not going to be able to defend yourself. And so really you want a procedure for managing disruptive patients, and maybe it's a memorandum to the staff, but it has procedures for them to follow. Also, of course, you have to have specific notice to the patient and or family, and then your contractual networks. What I'd like to do now is I'm going to turn
Kathleen,
it over.
may I? One point that you just had referenced, it's very interesting. When I began representing the healthcare community in the early 1980s, plaintiffs' attorneys frequently would ask for policy and procedure manuals, and we would be reluctant to turn them over, and the judges at that time, and for probably until the late 1990s, would conclude that those were not relevant or reasonably calculated to lead to the discovery of admissible evidence. Because in an abandonment or professional liability issue, the standard of care is what controls, and that's ordinarily established by independent expert witnesses retained by either the patient plaintiff or by the healthcare provider or defendant. With time, courts became more liberal in allowing that to be introduced during the discovery process, but not necessarily permitted into evidence. And as Kathleen indicated, that now is a problem. 40 years later, what we're seeing is that they routinely request that. In the event that there's an objection to it, the courts will allow the plaintiff to get a hold of those and then to not only question the witnesses on them, but also introduce them and claim that those are the standard of care. And if you don't follow it and you have a pattern and practice of not following, it becomes very problematic. So it's necessary to make sure that your procedures are being followed and that they're periodically audited and reviewed and make sure that they're brought up to date. And if you need to date those when you make substantive changes or additions, that's probably very helpful.
Thank you, Rich, for elaborating on that. And while we're at it, let's talk about the fact that employees can get deposed in a litigation and say, I never saw the policy, I never knew it existed. And how does that play in the court, Rich?
It makes it very, very difficult to defend, because if you weren't aware of it, there was not proper monitoring and supervision of employees, so there could be both direct liability by a group or a facility, clinic included. It could also be vicarious. You hired somebody, you weren't supervising them, they should have been on board with this, and it makes it very difficult to explain. Somewhere around 75 or 80% of our cases, we end up successfully defending, which means that we paid no indemnity, either by settlement, arbitration award, or jury verdict. And part of the reason for that is that the physicians are able to demonstrate very consistently several things. Number one, that the care was at or exceeded the community standard, and or it had no adverse impact on a causation theory with regard to the patient's damages. So if you were in a situation where all of a sudden you're not able to defend an important component, and that is no recollection of whether or not there was a policy, whether or not the individual who was charged with following the policy did in fact follow it, and that it was never audited to help ensure continuity of care, then a jury begins to consider that there's a credibility issue with the care that was delivered. Do we see that a lot? Not very often, but we see it with sufficient frequency that it's important to keep in mind that documentation is a critical component of what it is that we do. A lawsuit is filed ordinarily 1 to 3 years following the event in question, and the practitioner has moved on and has no independent recollection at that point. That's why the medical records are so critical.
Rich, would it be fair to say it's better to have no policy than a policy you don't follow 100% of the time?
Yes, because at least you can establish that what you do routinely or ordinarily, or in this particular instance that formed the basis of a lawsuit, comported with community standards. And I have a couple articles that I wrote last year on that in the hospital setting, that you want to make sure if you're in a hospital setting that what you're doing in that particular facility is consistent with what other similarly situated facilities do in your community.
Well, thank you. I'm going to turn it over to you now at the AMA definition of abandonment.
Thank you, Kathleen. My name is Richard Cahill. I'm Vice President and Associate General Counsel with the Doctors Company. And as Kathleen mentioned, I do virtual CME programs 50 to 60 times a year with Kathleen and some of her very esteemed colleagues around the country. And I also write articles on cutting edge issues of interest to the healthcare community. One of the hottest topics since the onset of the pandemic in the spring of 2020 is dealing with patients. How do you deal with patients who are uncomfortable with what's going on around them? Their whole life has been turned upside down. Sometimes their behavior is rude and inappropriate, sometimes even violent. And so patient termination has become a key issue. And there are lots of adverse consequences if that is done inappropriately. Medical board complaint, that's fairly easy to do. Just go to the website and click on complaint and fill out the form. Also, social media has become a new mode of complaining. Patients can do it virtually with impunity, but the practitioner is prevented by federal and state privacy laws of providing any protected health information other than to say what I recommend, and that is on our website, that we're aware of the complaint. We're not permitted pursuant to federal and state privacy laws to specifically address the concern. However, the practice is always amenable to meeting with patients who have issues and try to resolve them in an amicable fashion. It avoids the back and forth, and invariably after the first time a patient makes a complaint like that, they stop. Sometimes a more, I guess the word would be not threatening exactly, but a more direct and respectful response to a patient might be a letter saying, we're aware of this and we ask you to cease and desist. Otherwise, we may consider taking all available legal remedies. I've never seen one where somebody goes online after either that generic response is posted by the practice or a private letter is subsequently sent. That generally stops it. So let's talk about the definition of abandonment. As Kathleen said, abandonment is a difficult concept. It should be a last resort. I just lost the screen.
You're still there, Rich.
Kathleen, can you? I just lost the slides.
Okay, I will pop them up.
I have my own set of slides, and until you're able to retrieve them, Paul, I'll go ahead on my own slide deck. Thank you. So what is the definition of abandonment? According to the American Medical Association, the termination of a professional relationship between a physician and a patient at an unreasonable time and without giving the patient the chance to find an equally qualified replacement. And most of the states follow that either in their Medical Practice Act or in various judicial opinions. Termination is something that can sometimes be a little equivocal. And as Kathleen says, it's often determined by the standard of care in the community. Next slide, please. So what does the California Medical Association recommend? And this is fairly consistent in California throughout all the superior courts, and there's actually a judicial council approved jury instruction. 15 to 30 days is reasonable notice from the practice. The purpose for that is patients need to be given due process, which includes notice of the termination. And you have to be very careful, as Kathleen indicated earlier, that you do not have refills beyond the termination date. And I'll discuss with you what a termination letter should look like. But if you do continue to see the patient or take them back because they convince you that they're really not so bad, or you issue another refill after the termination date, what you've done is to reestablish the physician-patient relationship. And then to terminate a patient, you have to go through the same process that you did before, which if you've taken them back and the HMO requires that there be 3 new documented episodes of bad behavior, you essentially start over. Best not to do that. Next slide, please. To avoid an abandonment charge, these would be the things that you would want to avoid. And what is abandonment? It means that you've failed to treat the patient in a manner consistent with the community standard. And that would mean, for example, you do not do it during an active hospitalization. You do not do it while a patient is in acute phase of treatment or in the immediate post-op or post-procedure period, when the physician is the only source of medical care. And I have seen in rural areas around the country where someone is a super specialist, for example, a pediatric nephrologist in the Midwest, it may take a little bit longer for the family to find a suitable replacement. But those are considerations that look at if you're faced with that. If the patient is capitated, the patient cannot be dismissed until the physician communicates to the third-party payer to request approval for transfer of the patient. Remember, once a patient has been allegedly abandoned, frequently they'll go to the medical board and they will tell their tale of woe, which may or not be supported by the medical records. They'll go online, and it's not uncommon for them to go to their third-party payer, including Medicare or CMS, and complain that they were abandoned. That then prompts an investigation in California by the California Medical Board or by third-party payers, and we frequently see where somebody will make those complaints. That's why it's important to make sure that your records are properly documented. In the vast majority of cases, and Kathleen and I did a program on this earlier today, in which we discussed medical board complaints, probably in excess of 75% of the medical board complaints are resolved as soon as the agency is able to obtain a copy of the medical records and to make a determination that what the patient alleged to have occurred did not in fact occur, and what the physician did was perfectly appropriate. So those are very important considerations. Also, based upon the diagnosis, you cannot discharge a patient in any manner that would violate federal law. For example, anything that would be in violation of HIV or AIDS, showing that you were discriminating against them, anything having to do with the Americans with Disabilities Act. But if you have questions about that, you can call your TDC risk manager and get some guidance about how to deal with some of those issues. And they can be very sticky, but ordinarily when there's a dismissal and it's properly documented, that tends to be the end of the situation. And I agree with Kathleen's comment that you do not want to be in a position of referring your troubled patients to a specific individual. That's not your obligation. Also, it is not a very fair thing to do to your colleagues in the community, because they probably won't be aware at the time the initial contact is made that the patient had been terminated or discharged. Although if the practice were to call, that would be okay to have a discussion consistent with the treatment payment and operations exception in HIPAA, and also with the California Confidentiality of Medical Information Act set forth in Civil Code Section 56. As I'd indicated, 15 to 30 days is an appropriate length of time to give them notice. Probably closer to the 30 days would be better, and provide them with information necessary to obtain the medical records for continuing care. I always suggest that the termination be done with a letter, and that in the letter you indicate that you will make the records available to any provider that the patient suggests, and that you will remain available to discuss with the subsequent assigned physician or clinic things that may be necessary to ensure a smooth transition of care. That's perfectly appropriate also with the treatment payment and operations exception of HIPAA. When is termination acceptable? Quite a number of circumstances. For example, the patient is violent, comes into the office with a weapon, any type of for example, I've seen circumstances where somebody had mental issues and came in with a rifle. And frequently I'm asked, well, can we call the police? Well, yes, because if somebody is violent on the premises, you're the victim of a crime, and it's perfectly appropriate to call law enforcement, and you'll want to have a method set forth in the office where someone is alerted. For example, just a page that might say, calling Dr. Brown. That'll notify somebody in the office to make a call to law enforcement to have them come over. Law enforcement will respond promptly, and to do that is perfectly appropriate, as you're either the victim of a crime or the crime is occurring concurrently on the premises. But keep in mind the minimum necessary rule of HIPAA, which requires that you can only provide that information necessary to comply with the exception. If the patient threatens violence, you can also call the police. a number of years ago, I was going through LAX at about 5:30 in the morning, and I got a call from a practitioner in Virginia who said, a patient is standing outside my window throwing rocks. I said, we'll call the police. And while I was still on the phone, I heard a crash, and it turned out that the patient had decided that the rocks were not sufficiently damaging, and so got his car and drove it through the front window. And very shortly after that, the police arrived and arrested him for assault with a deadly weapon. Also, if patients bring lawsuits or threats of lawsuits against a physician, I've heard it so many times in the hundreds of depositions I've taken where this isn't personal. I'm just doing this to, redress my grievances. Well, if you're being sued and somebody's saying you've committed malpractice, it's very personal. And I think it's a classic circumstance where the doctor-patient relationship and the trust necessary to support it have been irrevocably lost. Also, the patient is non-compliant. And this is a circumstance where the patient has been advised of the treatment plan and consistent with the conditions of treatment. And I recommend that practices have a conditions of treatment that the patient sign at the outset of the doctor-patient relationship, which sets forth the rules of the road. And that also, I recommend that the conditions of treatment be posted on the website so that there's no question at a later date. And it should indicate that should the patient fail to follow the requirements as set forth in the conditions of treatment, termination may be appropriate. And of course, it would depend upon the circumstances. And non-compliance, if a patient is not complying, that can adversely impact outcome, adversely impact a wide variety of problems. And it's important to make sure that the patient is aware of that. And it's one of the meetings, it may perhaps the only meeting, the practitioner will sit down with the patient, explain the problem, find out why there's non-compliance, but make it clear to the patient that that cannot be tolerated as set forth in the conditions of treatment. Disruptive behavior, verbal abuse with the physician or staff in the office or on the phone or with other people present. In the early months of COVID, I had a case coming out of one of the southern states in which a woman was in a pediatrician's office and there were small children present, and one little kid was loud. I still can't believe somebody would do this, but she turned to the kid, I think he was like 5 or 6 years old, and said, "If you don't stop it, I'm going to spit on you." And that's exactly what happened. Of course, there was, negativity between both of the mothers. They called the police, and it was eventually resolved. Both families were counseled. I think it was the circumstances that the parents were unclear. They didn't know what the requirements were. Telehealth had not come into use. Both patients were ultimately retained in the practice, but it was made clear that that type of behavior was unacceptable. Often physicians will ask, can we terminate them for non-payment of the bill? It's perfectly appropriate for you to expect to be paid for your professional services. I might mention to you that I've seen it on 4 occasions during the 15 years that I've been working as in-house counsel, where a physician will turn somebody over to collections, and the first thing that the individual will do is file a small claims action for medical malpractice, stating that they're not paying the bill because the care that was rendered was below the community standard. How many times have I seen somebody prevail? Never. Because that is an action where, at least under the TDC policy, that's turned over to counsel. Counsel cannot appear in small claims, but they can provide you with the documentation and so forth. Also, the patient fires the physician. That can happen either subtly or very overtly. For example, the patient walks out of the office and either says to the receptionist on his or her way out, or specifically tells the physician, "I'm very unhappy with the care and treatment that I've received, and I'm not coming back." In that circumstance, and I'll describe it in a later slide, my recommendation would be for the practice to send the patient a letter, both certified mail and regular U.S. mail, that says, "This will confirm that at the conclusion of your visit on May 13th, 2021, you advised the practice that you were dissatisfied with the care that you were receiving, that you were terminating the physician-patient relationship and that you would not be coming back. Leaves nothing to the imagination. No, he said, she said, patient said that, it's in the record, and that's the end of it. Slide, please.
I'm going to pop up here really quick, Rich. If you can, please try to get a little closer to your mic. It's kind of going in and out a little. And then for the attendees, if people have questions, please put them in the chat, and I'll be keeping an eye on those for the end of his presentation.
Thank you, Paul. Can you continue to see a patient that's been sent to collections? As I just indicated, you can, but it becomes problematic. I think before a patient is sent to collections, they need to be reminded as early as possible that the account is in arrears, and it's a good idea to make some type of payment plan available to them. And then once they fail to do that, you can continue to see the patient, but if they haven't paid up to that point, it's not likely that they will. If the patient is not making payments towards the outstanding balance, you may reasonably dismiss them for non-payment. And it's not inappropriate to send them a letter and say, a review of your account indicates that you were $14,000 in arrears. I direct your attention to paragraph 3 of the conditions of treatment, which are also posted on our website, that you have agreed to make your balance current within 30 days. Your outstanding balance has been due for over 60 days, and we ask that you start resuming your payments, or there will be or may be a risk that you will be discharged as a patient of the practice. Again, difficult to discharge under certain circumstances. For example, the patient is in a critical or acute phase of treatment. You just need to make sure that you're watching the balance, or at least having your back office people watching the balance, so that you can keep abreast of that before it becomes insurmountable for a patient. As I'd indicated in an earlier slide, discrimination is prohibited through federal and state laws, including the United States Civil Rights Act. The physician is not free to terminate a patient because the patient is a member of a certain group, a certain religious or ethnic group, espouses certain political views. That would undoubtedly end up with a complaint to the Office of Civil Rights of the United States Department of Justice, and they may, under the circumstances, conduct an investigation. It's unethical to refuse to treat a patient due to sex, race, color, religion, ancestry, national origin, physical disability, and that would fit within the Americans with Disability Act, marital status, or sexual orientation. Next slide, please. This is a slide, I think, that we've already pretty much covered. The patient fires the physician, either overtly saying, I'm not coming back, or refusing to make an appointment, or notifying the front office when you're following up to notify the patient that he or she missed an appointment. I'm not coming back. I'm never going to make the appointment with you again. Request for refusal of care in the medical records. More and more, we're starting to see where patients are making determinations based upon their review of the internet that certain care is not something that they choose to have. And I think refusal of care needs to be documented. For example, I had a case several years ago during the height of our economic downturn in about 2009, where a practice was very concerned that a man who both of his parents had been smokers and had died of lung cancer. This gentleman was a 30-year, 2-pack-a-day smoker, had hemoptysis and a serious cough, and he refused to have any scan other than a chest x-ray. It was a pulmonology practice, and they were very concerned about it, but they didn't want to just tell him that he was no longer part of the practice. They sat down and worked with him. He was amenable to having his wife be part of the dialogue, and the wife candidly said, well, he lost his job and we don't have any insurance, and we're not able to afford whatever the scan was that they wanted, a CAT scan or a MRI. So In the event that a patient refuses care, it's important to document it, but also document that an attempt was made to find out why the patient was non-compliant. And also then consider a refusal of care form, which very simply states, like a consent form might, I have been advised that this is the next recommended course of treatment. I have been advised of the consequences of failure to get such treatment, and I make the free conscious decision not to undergo that. Sort of like in the old days when we had the AMA forms when patients walked out of the hospital or left the emergency department prior to termination of services. Patients often will not sign that. Well, it needs to be signed by somebody. It can be signed by the nurse. It could be signed by an administrative person saying, patient was advised of the consequences and asked to sign this form, but refused to do so, and then sign and date the form. It's often, I think, effective to advise patients in that circumstance that the document will become a part of the chart. Patients then become concerned that if that becomes a part of the chart, that they may be seen to be non-compliant. Also, when patients use specific language, whether it's X or otherwise, you know, when I first started doing this work, we always advise people, don't put that in that bad language in the medical record. It reflects badly on you as a professional. But simply saying that, you know, Aunt Betty used foul and vulgar language and you don't indicate what it was at the time of deposition, trial, or arbitration, Aunt Betty will come in and say, oh, I never said anything bad. If those words, patient stated X, put it in quotation marks so that there is no misunderstanding at a later date, because at a later date, should it become necessary to reference the record, unless the record has been somehow impeached by an alteration or a late entry, the record will win the day for you. So use the words specifically. I don't want that care because I don't think colonoscopy is a good thing for me at this stage in my life. Patient advised of the possible consequences and refuses to undergo a colonoscopy. Also, we have a sample refusal of care form, and you can get that on our website. And Kathleen, I think, can be more specific and tell you where that is. Next
if anybody
slide,
wants to put their email out there, we'll be happy to send. I'll be happy to email it to you if you send me an email.
So what is the process of termination? And it's a fairly simple process. It should be formally completed, not just assuming that you didn't like the patient and that you're not going to make another appointment, or that the patient hasn't come back for 6 months and therefore has terminated care. The patient may have a sketchy history of making appointments. So the patient should receive a written letter of dismissal. It's not required to give a specific reason for the termination. Something as simple as a review of your chart, or in consideration of your last visit in the office, it is apparent that the trust necessary to continue the physician-patient relationship has been undermined, and therefore we are no longer able to continue treating you as a patient of this practice. And keep a copy of the termination letter in the patient record. The next slide is actually the dismissal, and it should be sent two ways, both first class and certified mail. We've had circumstances where patients see something coming from the doctor, and what they often will do is not sign it, and after 2 tries, the post office will return it. But if it's also sent first class mail, in California, if it's sent and you have evidence that it was sent, then it's presumed received. And keep a copy of the letter, whether the copy is the first class or by certified mail or FedEx or one of the other services. Make sure that goes in the chart. Interim care provisions. Offer interim care for emergencies only. And this is very effective. I suspect that most of the attendees this evening do not treat emergency circumstances in their offices. And if somebody were to call and say, I'm experiencing an emergency, I suspect what most offices would say is, please hang up and call 911 immediately. We cannot treat emergencies in our office. The patient may be referred to the ED or to urgent care, but I've seen circumstances in which a distraught patient attempted to drive himself or herself to an ED and ended up having an accident en route. Better to suggest that they call 911. Also, the interim provisions. They should make sure that they have prescription medication sufficient for the period of time before the termination becomes final, but do not refill them beyond that date. May provide refills for routine medications at the time of the dismissal letter, but not ordered after the date of termination. What do you have to say as reasons for termination? You can say no specific reason other than in light of recent events or in light of your last visit dated, June 15th, 2021. It is evident that the physician-patient relationship has deteriorated and this practice is no longer willing to see you as a patient. Or inability to achieve and maintain rapport of therapeutic relationship. You can specifically mention non-compliance. But before you put non-compliance as the reason, make sure that your clinic chart is accurately documented. Inappropriate behavior. On the dates when the behavior occurred, make sure it's properly documented and don't be bashful about having members of the staff write an entry in the notes saying patient called me XYZ name, told me that I was unprofessional and that whatever other inappropriate behavior or words were said. Also, the patient fired the physician. A letter indicating to the patient that as a result of your last visit, during which you advised that you were no longer a patient of the practice, we are confirming that your relationship has been ended. Those are perfectly appropriate reasons. I think we've already covered this. The dismissal letter needs to be sent and placed in there. I'll let you take a moment and read this. If you'd like a copy of the slides, those will be made available to you. And this is a fairly standard sample dismissal letter, and it consists of 2 pages. And Paul, if in a moment you'll advance the next slide, then they can finish reading it. And I think it's important to make a reference in the dismissal letter how they are able to get a copy of their chart. Enclosed, please find a HIPAA compliant patient authorization. Please sign and return this once you determine who your new provider is. Also, please be advised that we will be happy to confer with your new physician to help ensure smooth transition of care. And that looks very good. Nobody can criticize you for doing that. This is always a tough one. Everybody wants to say, just give me another chance. Well, I've never seen somebody who, is really, really rude repeatedly change their method of interacting with your staff. They may not be inappropriate with you, but they likely will continue to be inappropriate to staff, making snide remarks about having to wait for so long and so forth. Once the termination has been sent, do not agree to meet with the patient or the family to discuss it. It's a non-appealable issue. Do not, you as the physician, ever get involved with the dialogue. Well, if I could just speak with Dr. Stillwell for 5 minutes, I can convince her that I'll be better. I think your office should have a policy that once a determination is made, that should be the end of it. You shouldn't have conversations with dismissed patients. Office managers should handle the calls, and you should develop an office format for how best you'd like to handle that. And also, patient safety risk managers can assist you in coaching or in helping to prepare language that would be appropriate in advising patients that you're no longer going to take them back and that they're no longer going to be allowed to make appointments. Once in a great while, we see a circumstance where it's not flagged and somebody makes an appointment and it turns out that they have already been terminated. Kathleen, what is your recommendation in a situation where a practice has clearly terminated the patient has slipped under the radar and now made a new appointment?
Well, what I find, the example that I will give actually is the most frequent call I have. If you're using a robocall system or a program system, maybe I came to see you and I got dismissed, but I had an appointment for 6 months later, and then the patient gets a reminder message, or somehow it's not taken out of your EHR if you're using a messaging center. And if I show up, you need to see me because the mistake was on your end. So you can't say, well, I'm not going to see you. What you could say is, well, I'm sorry, it was a human error on our part. We will see you today, but we will not see you after today. And so people might say, well, I drove, I made arrangements to get here. So the gracious thing would be to say, I'll see that one time, and then you document in the record why you saw them. Patient was dismissed March 15th, 2021. A notification system in air confirmed upcoming appointment, and patient showed up, patient was seen. Or if you say, I'm not going to see you, and you're standing, you're just asking to be bad-mouthed on social media, because I have offices that have gone through this. The other thing is, if your staff needs to be alert to this and somehow put a banner on your EHR on this patient, or when the patient is set, how are you going to know, and your staff is taking a call and making an appointment? Maybe you keep a list, like if you go into a store and it says, don't take checks from Catherine Stowell and Rich Cahill because they pass bad checks. There's, you have a place you can check that. So I don't know how you're going to do it, but you have to, it's your responsibility that your staff doesn't make appointments with people that have been dismissed. And if people get an appointment and show up, you want to be sure that you're prepared for how you're going to handle that. Because typically they'll come in and then someone will say, well, I don't know why you called me for the appointment when you dismissed me from the practice. And then somebody looks it up and says, oh yeah, we did dismiss you. We can't see you. That's going to be offensive to the patient. It doesn't happen often. Usually I see it with the robocall system is how we see that, Rich. But I think that, your staff has to be part of the solution for this. And the other thing that comes up that I want to say about when patients are dismissed, if they're dismissed for cause, and I know that, of the things that you can dismiss for: non-payment of the bill, non-compliance, rude, inappropriate behavior, violence or threats of violence. Also, if they're suing you, and if they have sued you or they've sent a notice of intent, not just the patient gets dismissed, but the whole family gets dismissed. And that's important. And then I get this call. Well, the patient said that they're going to withdraw the lawsuit, so they want to come back. Should we take them back? You heard Rich say, don't take them back. Please don't take them back. You will be sorry. If they were willing to sue you once, they're going to be willing to do something to you again. The other thing, and maybe Rich, you can elaborate on this, if an attorney takes a case and then says, well, they might file a complaint and not serve it, and that can sit in the courts for several years. And so, Rich, what is the implication of that if you take a patient back and they're sitting there with a filed but not served complaint?
Well, we've got new systems in place since the Discovery Act of 1986, so they can't sit on a complaint for years. They have to follow the rapid progression established by the Superior Court in each county. But the problem that I see with it is what they may be doing is using it as an opportunity to come in and surreptitiously record visits and things like that. And my rule of thumb, particularly in California, is do not allow patients to record visits, surreptitiously or otherwise. And it might be worthwhile to state in your webpage, recordings, audio, video, visual, or digital may not be made at any location on the premises consistent with federal and state law. California has a very strict surveillance statute under Penal Code Section 631 that says unless everybody explicitly agrees to the recording, it's illegal and you may not do it. And there's only one purpose for which it can be used, and that's to prosecute the individual who made the illegal recording. If you find that people are using the recordings, and I've seen this in my private practice when I was representing a health system. On one occasion, an elderly gentleman was on the verge of death, and a grandson decided to show up with a video camera at the hospital and started walking around to all the providers asking questions and kind of making a pest of himself, would be to say the least. And I said, have him step out in the hallway, have security and the charge nurse say, you're not welcome here anymore. We request that you leave. And if the person doesn't, escort them off the premises, because at that point they're committing a crime, not only disrupting under Penal Code Section 415, loud and unreasonable noise under the circumstances, trespassing, but they're also violating the electronic surveillance statute. So I recommend that you either post that on the website or simply have a plain visible sign in the reception area that says electronic recordings are not permitted on the premise, consistent with federal and state law. Kathleen, that concludes my portion of the program, and I would turn it back to you at this point for slide 32.
Thank you. And thank you, Paul. On the next slide, it's just some additional considerations. Capturing the patient's words and comments with quotes around the inappropriate words or comments is the most important thing you can document. And historically, you might have heard, well, we aren't going to put in there that the patient dropped the F-bomb or that they said foul language. Well, contrary to that today, that's going to be really your golden ticket to get rid of that patient. If you need to talk, if you have an HMO, if you see Covered California, Cal Optima, if you're in an IPA, an HMO network, your contract says before you can terminate them that you have to notify that payer. And the payer, I will tell you, will say, you need, I call it 3 strikes and you're out. So one of the things that I find in dealing with practices is that the people are most frequently that are disruptive and inappropriate are so on the phone with your staff. They're fairly pretty good with the doctors. They're typically not inappropriate with the physician. And the problem you have is the staff says, you know, every time Mrs. Jones calls, she's so rude and she yells and she criticizes me on the phone. And then when she comes in the office, she's pounding her fist on the table, and it's really, you need to do something about it to you, the physician. And then the patient comes in the room and you say, well, Mrs. Jones, my staff tells me there was a problem in the front lobby today. And I'll tell you what the patients will say time and time again. Well, wait a minute, who told you that? There was no problem in the lobby. There was no problem on the phone. If your staff told you that, then you have liars working for you. I never said anything. That isn't what happened. And then you're trapped in a corner. And so we don't want you to even have to be in this conversation with these patients because they're going to say they didn't say it. So this is where you really have to have your office manager trained to intercept that patient and say, I want to chat with you briefly. The last couple of times you've called the office or come in, you have been disruptive and it's not acceptable. And the line that I train everybody to is we have a 0 tolerance for inappropriate and disruptive patient behavior on the phone and in the office. I want to stay on the phone and help you, but if you continue with that language, I won't be able to. And same thing in the office. And so it's got to be documented. And what I find is people say, well, you know, today the patient, you know, pulled out all the stops and was really nasty, but it's the first time we're documenting it. And so it would have been probably the 5th or 6th time because nobody's documenting it on the phone, because when your receptionist takes a call, number one, there's not a visit that day. So you have to decide, how are you going to get that note in the chart? So I'll give you an example. Someone calls on the phone and they say, I need an appointment. I need to see Dr. Cahill. I'm sorry, Dr. Cahill has no openings today. I could have you see our nurse practitioner, or maybe Dr. Cahill could see you tomorrow. And the patient says, you're not listening to me. I want to see today. What kind of idiot are you? You can't even make an appointment. Even something like that, that's rude. And this is where the staff needs to say, I'm sorry, just trying to help you, but we have a zero tolerance for that kind of comment, and I would like to stay on the phone to help you. And it can get exaggerated. It can come to conclusion. The patient can hang up, but your staff has to always maintain in a professional, composed point of view. But a lot of times people aren't used to being talked down to and being called names or being bullied. And so this is where that whole thing at the beginning I talked about, a hostile work environment, comes into play. So how is this going to be documented? Patient, it would be a documentation as, for example, patient called for appointment, advised doctor not available, offered option of NP or urgent care or appointment tomorrow. Patient responded in quotation marks. They don't have to write the whole thing. What's wrong with you? Can't you even make an appointment? What school did you go to? Are you just an idiot and you can't make an appointment? End quote. That's all we need. We don't want the whole story and then I said this and the patient said that. You want to capture it. If they use bad language, we really need the language in there. Now, I know that sometimes people aren't going to be comfortable putting words in, but you can put enough letters so that we know. Because to document, patient used foul language, was inappropriate and used foul language. Rich, how is that seen in the court or in a grievance or in a complaint with the medical board versus patients raised her voice and said, you're just a GD, A, whatever.
GD lawyer, you say it.
I'm going to say it.
It's important to capture both the tone, the demeanor, and the actual words used. Otherwise, you'll have somebody. When I first started practicing, I was in the DA's office. And when we do the preliminary hearing, some of the fellows, and it was mostly young men, selling drugs, doing bad things, they looked pretty bad. And then they were let out on bail. I didn't see them for 60 or 90 days. Trial shows up. The public defender went down and bought them a suit, got them a haircut, and they looked real presentable. And you didn't have the sense that if you had seen them at the preliminary hearing, when they had just, been brought in after committing a crime. And the same way with a year later, used foul language. Oh, the thing that I see so frequently is, there was a miscommunication, there was a misunderstanding. Well, if someone calls me a GD, whatever, and that's in the record, there's no room for misunderstanding. They're going to have to impeach the record, and that's an easy one. Unless there's some evidence of altered records or addenda or something like that, you win on the record because it was made at or near the time of the event in the course of your business. It's considered reliable, and not only can you rely on it as evidence of what happened to refresh your recollection, it's independently admissible and will be entered into the record so that the jury can see it. So using, like Kathleen said, a letter or two here, and then a dash, and in quotations. No one is saying that you use that language. You're just simply repeating it. And by using that type of a dash, you get the message across without being too overly vulgar about it. So I think that'd be the best way to handle it.
I also want to say something that's really important, and now we're in the era of open notes, which began in April of this year. If you have an EHR, and if you don't have an EHR, patients have always had the opportunity and option to request a copy of their medical records. And I have many physicians or office managers will say, well, I don't want the patient to look at the record and see we wrote that. They're going to be upset with us. Said, oh, well, really? That's okay. But they also then, when they see it, and I've probably had 50 calls on this in the last 2 months, that the patient says, I looked at my notes or I got a copy of my records, and the doctor or not the doctor, but the staff wrote a note that was derogatory about me and said I said something in quotes, and I want that out of my record. Well, under the HIPAA federal and state HIPAA laws, it's very specific what a patient needs to be told, and the law has been in place since 2013. If you would like something changed in your record, please provide it to us in writing, what you want removed and why. The doctor will review it and will respond to you within 60 days. Be aware that your request will become a part of your medical record, and the doctor's response will become part of your medical record. It's important to tell them that, because what they do is they say, I want this taken out of the record because I was having a bad day and I was unhappy, or I never said that. And then the physician reviews it, and I encourage physicians not to take 60 days to get back, but to do it within a week or so. And the response letter is something like this: Dear patient name, I have reviewed your correspondence of date requesting a change in your records. Please be advised your request is now a permanent part of your medical record. After careful review of your records and consideration of your request, I have made a determination there will be no change in the medical record. The record is accurate. Your request is in the record, and this letter of response is also now a permanent part of your medical record. And people get really upset, but that's the way it goes, and that's the problem. And so what you have is patients don't realize that, and that's why I like, especially on the phone, for somebody to say, that's inappropriate, we have a zero tolerance, and I will be documenting your comment in your medical record. Now, if you have somebody who's been pretty good all the time and they just have one off thing, maybe you might give them a pass once, but you don't want your staff to give them a pass twice. The main thing is this is an issue between your staff and the patients, because physicians shouldn't get involved in this conversation, other than if you have to say, you know, we may, you know, you want to keep coming here, then you're going to have to be, you know, minding your language and your behavior. Also, many times the call that I get is the patient is fine. It's grandma and the grandson or the gangbanger nephew or son or daughter is bringing them in, and they're the ones that are inappropriate, and they're sitting in the lobby on their cell phone having a conversation and using foul language, and everybody's in the lobby like, what are they talking? You know, that's not okay. So then, you know, your manager needs to come out and say, excuse me, you know, if you'd like to step out and use the phone outside the office, but not in front of people. And this is the thing, is that people get very on the defense if you confront them in front of a group. So you don't want your staff to go up to this person in front of everybody. Instead, the front desk can tell the manager, listen, we have somebody who's really obnoxious. Can you help? Come out and say, excuse me, sir, could I speak to you for a moment? And can take them outside the door of the office or bring them into their office and say, you know, I'm sorry, but there is concern because of your language, and you're being very loud and it's making people uncomfortable and it's disruptive, and we have a zero tolerance for inappropriate language and disruptive behavior in the office. I know you've brought your grandmother today or your mother. We'd invite you to step outside. If you want to give us your number, we can text you when she's ready and you can come and get her. You want to work with people because this is a customer business, and you want to always be looking at the patient as your customer, but the people that bring them also are indirectly an indirect customer as well. Also, you don't want to meet alone with a patient who's upset. And I say this particularly for the office manager, because it will become a she said, he said, she said, if there's no witness. So I always say, for your office manager, have someone come in. The doctor shouldn't be coming in. And if you're going to talk to the patient about a problem, it's recommended that you have your MA come in, or you have your office manager come in, or just say, you know, I've asked my MA Rich to step in while I talk with you, because as Rich said earlier, the courts love you and people have great confidence in the physicians and they respect you. But that doesn't mean that they won't lie about what was said if they're trying to get themselves out of a corner or out of trouble. So it's important. I am in Orange County, and I want to tell you that I have a patient that showed up. I have a practice that had to dismiss the patient from an Orange County practice. And I said, did you ever get the record from the last physician? And they didn't, but they called that physician. They had the name. And that patient had been dismissed from an LA office, and the LA office told them, yeah, that patient lives in Lancaster, because we were wondering, why is he coming from Lancaster to Orange County? Because he has been dismissed from 8 practices between Lancaster and Orange County. He's probably headed to San Diego. So, you know, you get people who are chronic disruptive problems. You also get people who may be have mental health issues. You have people who are homeless. You have people who have cognitive deficit. So, you know, you take potluck, what you get a lot of different things. So you want to be sure that you have a witness. Certainly, we don't want your staff to engage in any arguments with patients or family. It's better to say, and I call it the timeout. If it's on the phone, I do a training and say, excuse me, I'm sorry, I just was tapped on the shoulder. I have an emergency. Please hold. You put the person on hold, and then you don't go back and you have someone else pick up the phone and say, I'm sorry, Kathleen was called away for an emergency. She asked me to get your name and number, and she will be available in about, you want to at least give an hour for a cooling off period for someone who's really outrageous, or 30 minutes at least, and she will call you back. Because the literature shows that people do cool down a little bit, and it's kind of a timeout on the phone. And if they say, well, I want you to help me, I'm sorry, she just asked me in this emergency to let you know she'll call back. And then you got to be sure and call back if you set a certain time, because otherwise they'll be upset. Of course, staying calm and respectful, that's really important. And this is really something you've got to, make an important position to your staff, that they don't have a knee-jerk reaction and say, you can't talk to me that way. And document. We've heard about the documentation, and it's important because it's absolutely, that is your silent witness that will speak for you. If there's a complaint to the medical board, if there's a complaint or grievance to the health plan, you will need that documentation to be attached to an exhibit. And once they see that the patient behavior and you have, conversation is documented, or a part of that, or the worst thing that they said, I always say, don't write the whole thing, just pick the worst part of what they said. That's the document. The next slide is also references documentation issues. And I think we've talked about it, but the behaviors need to be in the patient medical record. And this will also help have you have appropriate rationale for a termination, and document termination by the patient. This is very important. When the patient says, you know what, you people are a bunch of idiots, I'm never coming back here, please be sure that you do a formal letter that says this will, in follow up to your telephone call of September 9th, 2020, when you advised, and put in quotation marks, I am never coming back here. Put that in quotation marks in the letter. Of course, with the doctor's company, we're always available to assist and coach you on this. And we also, if you're with the doctor's company, we have a packet for patient termination with sample letters. If you're not with the doctor's company, there are other great malpractice providers out there, and I'm sure that they have something comparable. So we really want to help support you so that you don't have to start from scratch. And then I always say, let me read the draft to be sure that we've got it right. I had a doctor the other day say, I wrote a documentation of a termination letter. Would you review it for me? He sent me, it was a 2-page letter, and it went on and on in great detail about the things that had happened. And I said, okay, this is good. Now that you've vented your soul on this letter, this was good, but this isn't what you can send the patient. Don't even put it in the medical record. Let's narrow it down so it's short and to the point. And he was very appreciative. And he said, best thing I ever did was, I kept giving this patient chance after chance. Best thing I did was finally decide I'm going to cut bait. You have to be sure that you have a copy of the termination letter in the patient's medical record. And when you have an unruly patient and I get a call and they say, this patient's been coming in and they continue to be disruptive, I say, did you ever check with the doctor that they were with before they came to you? No, I said, well, under HIPAA laws and regulations, federal and state, you do not need a patient's permission to call a physician that has been a prior treater, or if you have a collaborating or a referring physician, you can call and you can ask a question. You don't have to necessarily get the records, but if you called and said, listen, I have Kathleen Stillwell here, and I know she was with you before, and I'm not quite sure why she left, and just wanted to check because I just wanted to check into that. I don't really want to get a copy of the records. And they'll say, oh, well, that patient was dismissed from the practice. And if you had gotten their medical records, or you can request them, you'll see that there should be the patient termination letter is part of the medical record. So that is something that is often helpful to see. I think,
Kathleen, I might mention that it might be worthwhile to make available the Medical Society through Paul our program on open notes, which I think you and I have done somewhere around 21 times. It's a very hot topic. It's the latest thing that the federal government has done, and it might be worthwhile if there's sufficient interest early next year for us to do that program.
That might be a good idea. I think what I wanted to do is see, are there any questions? Because
I've got 3 questions here, one on this slide actually, specifically. So what part of the chart do we document bad patient behavior or language? Make a chart note encounter, or as opposed to an admin note?
If it's in the, if the patient is there for a visit, it should be in the visit note. If the patient is calling on the phone, you don't have a visit note. And it could be an administrative in a task. Where do you have your staff document what happens in a telephone call? That would be there. That is part of the record. And I want to say something about the record. When patients ask for a copy of their medical records, if it's EHR, they typically don't get the administrative tasks and the administrative notes. If a subpoena is produced that's valid for the records, then all of the administrative notes and tasks go with the record. If you have a manual record, could just make a notation on that date and the time and make an entry. Patient called, requested appointment, advised no appointment available. And you don't want to be making subjective comments like patient was upset, patient was angry. That's subjective. You don't know. But if they raise their voice, and if they use language that's inappropriate, that's objective and that's factual, and that's really what you want to put in there. And you want to have it in quotes.
I've got 2 more questions up here if you want me to hit them now, and I'll again invite anybody else to put new questions in the Q&A or the chat.
Sure, let's go ahead.
What if your practice refuses to see unvaccinated patients and the patient claims religious exemption?
Well, I'm going to make one comment, and then I'm going to ask Rich, our attorney, to make a comment. Okay, Rich? First of all, it's challenging. We're seeing now patients that this is an issue. I want to say that if you have a religious exemption, you have to have it in writing from a rabbi, a priest. You can't just say, I have a religious exemption. That doesn't count. So the first thing is they would have to produce that. And if they say, I have it, I would say, we need to see it. In terms of refusing to see them, that could be a slippery slope. And that has to do with, I'm going to go back to, I'm a nurse, and I remember at the very beginning, well, before we even knew about HIV, we didn't know about it. We had what we called immunosuppressed patients, and we were very careful with them. And then we got HIV, and we didn't have an HIV test. We treated everybody like they had HIV. I think you have to almost use that premise that we have to treat everyone as though they could be positive for COVID. And that's why we ask them to mask. And that's why we have, our practices following all the CDC and the Department of Health and State Department of Health guidelines. And so I'm going to let Rich address the discrimination issues, but I know that today I see practices that say, you have to show us what you have. You can't just say, I have it. And it needs to be they're asking for it on a letterhead. And as you know, physicians don't even want to write exemptions for medical exemptions now, because the medical board is auditing the medical exemptions. And so I have physicians just say, I won't even write one. So I haven't had any, I'm sorry, I've had one call about a religious exemption. And I said, tell them you want it on the letterhead from the priest, the clergy, the rabbi. And then they said, well, what about these mail order people that can do weddings? And I said, well, let's see what they give you. And they just couldn't come up with anything. And so then they never came back because they couldn't produce it. Rich, I'd like you to weigh in on the issue about, would this be discriminatory treatment to refuse to see them?
It always depends upon the circumstances, Kathleen, and I think this has been seen by the U.S. Supreme Court over the course of, well, since Justice Amy Coney Barrett was confirmed. They're taking a great deal, much more careful look at the religious issues, and I think it's important to see how that develops both with the court. I think I read this morning something like 26 states are challenging the mask requirements, the vaccination requirements, and all of that. We don't have, I think, a clear indication in the law as to what the status of that is. I think over the course of the next month, we'll have a better idea because the courts will rule on this. The U.S. Department of Justice under the Biden administration will come up with guidelines. But I think the first step would be to say, you know, it is our preference or whatever that you be vaccinated. And if you believe that you have an exception, please put that in writing. And I think the court recently said that while all this is going through the courts, somebody cannot be forced, for example, in the military to have a vaccination until the appeal has been exhausted. So I think the best thing to do is when people say that, just to indicate to them, first, as Kathleen said, we follow CDC requirements, and if you're going to come into the office, we expect you to practice social distancing, safe practices, masking. We'll sterilize it, just like before telehealth became an important component of a practice. Also, that may be a reasonable alternative, is to say that we have telehealth visits, but the question then becomes, in your practice, if you have to see this patient under this clinical presentation and a telehealth visit is not appropriate, that then may become an issue. But I think it's appropriate to have the practice simply say to somebody, please state the basis for your objection so that we can have it reviewed. And we do have a practice in South Orange County that we regularly recommend to our practitioners who deal with employment issues, both for employees of the practice and various other employment-related issues, to assist in this type of a conversation. And should that come up, and you're a member of TDC, please contact us, and we'll do our best to get you that information.
I'm glad Rich brought up the telehealth visit, because I was just going to say that has been the alternative that offices have been using for someone who said, I won't wear a mask, I'm not vaccinated. They say, we only have telehealth visits available for that. And then if they say, well, you know, I have a sore throat, or I'm very congested in the chest, I'm sorry, we're not able to evaluate you on telehealth for your chest congestion because we can't. Listen, we recommend you go to urgent care or the emergency room. That's what most of the office practices are doing.
And that's been an effective approach. Oh, did you have another question?
Yep, I do. Okay. I'm curious about family member caregiver issues. It's pretty clear that patients are not, that when patients are not adhering, and when family members are verbally abusive. However, what advice can you provide regarding when patients' family members impact treatment in other ways, manipulation, speaking over patients, etc.? Naturally, not in overtly abusive ways. We have established avenues for that as well.
Well, I'm going to comment and then have Rich chime in. I see this frequently. I've seen it with my own family. And so that's when my mother had a companion of 20 years. And when they would go to the doctor would ask Bob a question and my mother would answer the question. And the account was one of my accounts, a TDC account. And I told the doctor, I told my mother, I said, can you come out for a minute? And then I said, wait here. And I said, I want you to go sit in the waiting room. She goes, why? I said, I'll come out and get you in a minute. And then I went into the doctor and I said, I want you to see him without my mother, because, and I was there because I took him and I had to take him everywhere. And I said, because he needs to answer the questions. So he said, thank you. He said, it's always so hard when a family member or someone who's in the visit. So the best thing is to be clear and say, I'm going to, you know, ask some questions. And if somebody's there, Mr. or Mrs. Mr. Cahill, I'm going to ask Mrs. Cahill some questions, and I would like to please have you, you know, let her answer the questions. And when I'm all done, I will ask you if you have anything you want to add. So you have to really take control of that and not let them railroad you into do that. Short of that, say, I'm going to have, you know, have the MA bring the patient in and have the other person wait outside, or come in and say, I'm going to talk with the patient. I'm going to have you wait outside or go back to the waiting room. We're going to, you know, I'll talk with you after I'm done, because you really, you owe it to the patient. The patient is who should have your attention. And it can be uncomfortable for someone to tell them. And I always say, it's better that the doctor doesn't have to say that. So you tell your MA, I only want you to bring Mr. Cahill in, leave Mrs. Cahill in the waiting room. So when the MA comes to get Mr. Cahill, Mrs. Cahill stands up too and says, wait right there. I'm going to take him back and then I'm going to come back for you. And then you leave and take the patient. The other place where we see this as an issue is when a parent comes in with a teenager. And I want to address this because the California minors confidentiality law is very clear. Minors between ages of 12 and 18 have privy to treatment for 6 things without their parents' knowledge or consent. And that includes pregnancy, family planning, STD treatments for sexually transmitted disease, alcohol, drug abuse, or alcohol, drug, or mental health treatment. Now, that means that their parents, if they're going to use their parents' insurance, the parents will get an EOB. But all things considered, when you bring a 17-year-old in, how comfortable is it to ask the 17-year-old about if they're sexually active in front of the parent? That's not very comfortable. So usually family practice, OB/GYN, pediatricians will ask the parent to step out or say, don't bring the parent. I want to talk to the patient alone first for 15 minutes, and then we'll come and get the parent, because they are entitled to that confidentiality. And also, just in reference to Rich mentioned the open notes on an EHR, after age 12, it's recommended that the parents be locked out of the patient's EHR. Now, when you're 12 years old and your parent says, I can't get in your record unless you sign this release, you're 12 years old and the parent asks you to sign it, you probably sign it because you're not thinking you're going to be a 15 or 16-year-old promiscuous girl or boy. So then you got to rescind it later if the behavior changes. So there's a lot of issues with this EHR issue access, but primarily what you want to do is curtail the patient visitor. I see a question that just popped up, but it was gone before I could read it. Rich,
Kathleen, I think that's what you just answered.
Okay, I didn't know. Rich, do you want to add anything to what I just said?
No, I think it was comprehensive and accurate. Thank you.
Okay, so
I've got one here, I think, Kathleen. A patient has been non-compliant ×3 and documented, and the patient is terminated. If they are dependent on certain medications, opioids, other meds, and you prescribe 30 days of the medication, if they can not get a new MD for 60 days or 90 days or more, are you responsible to continue prescribing the medications until they find a new MD?
Well, you have to consider
if you
it.
to reestablish the relationship.
Yeah,
and that's what you have to be very careful about.
Right. And one of the things,
in my opinion, patient communication is critical so that the patient understands, if you continue in your non-compliance, we will terminate you, and make sure the record is clear about that. And yes, they may have a need for the medications, but they also, if they're going to be terminated, that's a radical thing to do, terminating a patient. it needs to be accurately documented so that the patient was told and completely understood and chose to take that course of action. And as we may have discussed last year when we did a program, I think for San Diego, on the CURES program, the utilization review of scheduled drugs, it's important that they also have the option of going to an emergency department and at least getting medications through that.
Where I find this most often an issue is with pain management practices. So you can't just cold turkey stop certain medications because they could go into withdrawal. So an example would be a medication that the patient has to continue, and the physician says, I'm dismissing you and I'm going to give you, because scheduled drugs can only be prescribed 30 days at a time. And maybe they're not going to be able, they're an HMO patient. They may not get an appointment for 60 or 90 days. So you can say, I'm going to provide you 90 days to allow you to get reestablished with another physician. And you will have to come into the office and pick up, but you've arranged this before the termination date. And so they can come back in a month and pick it up. You could mail them the prescription. With e-prescribe, you could prescribe it, but it's a deal that's negotiated before the termination date. So it doesn't null and void the termination date. You've agreed in advance. And I do see this with pain management practices usually because they're concerned about withdrawal, and it can take time for somebody to get into an appointment. Anything else? We're 4 minutes over. I just was going to put the closing slide out unless there's any other questions. Rich and I are here and we'll take any other questions. So a pessimist sees the difficulty in every opportunity. An optimist sees the opportunity in every difficulty. And so we leave you with these words from Winston Churchill because we believe you are optimists, because you're still here months later into the worst pandemic of over 100 years, and you're still showing up every day, taking care of people, putting yourself out there, giving compassionate care. And in an evening when you were exhausted and had a day of all days today on Wednesday, you still showed up for the CME program tonight. And that says something about who you are and how you are valued, and the communities you serve are grateful. And so on behalf of the Doctors Company, Rich and I want to extend a great gratitude. Thank you for the care you provide in the communities, and may you all enjoy the blessings of the season of gratitude and have a wonderful holiday ahead. And we will hope to see you in 2022.
Well, before you pop off, there's a late question came in. I'm going to try to get you on. What about a circumstance where the insurance company is not authorizing treatment, causing the physician to feel that they are being forced to treat the patient below the standard of care, work comp, for instance, in California? Is this grounds for termination?
Rich, why don't you take that one? Oh, he left already. Okay, I'll take it then. So if the insurance company is not authorizing the treatment that the patient feels that the physician feels the patient needs, I'm going to tell you that I deal with, a couple hundred calls a year about this kind of thing. And when I start talking to the doctor or to the office manager and asking questions like, have you appealed? Well, no. Well, we've sent the request in 3 times and it's 2 months later, we still have nothing. I said, no, that's not an appeal. That's like the definition of madness, doing the same thing over and over again and getting the same result. You need to find out who is the medical director for the insurance company and submit a letter from the physician, and the office manager can authorize it and said, we've put these requests in. I put a request on this date, and nothing. And this is a matter of concern, this patient's condition. You have to put that letter, you have to send that letter. That's what it takes. That's why they never authorize, because people just keep requesting authorization. The other thing you have to do is go to the ombudsman, and the office manager can call the ombudsman at the insurance company and say, I work with Dr. Hagee's office, and we have a patient, and we are concerned this patient could be at risk for not getting what they need, and we need to know who is the medical director. We want to send a letter about this to the medical director. I'm going to tell you, if you go that route, 90% of the issues usually will get approved. Or if it's a work comp, you go to the adjuster and you send the letter goes to the adjuster who's getting the information, and you call the adjuster and say, this is a problem. We're going to document and send you a letter that says this patient is at greater risk for exacerbation of the current injury or for complications if they don't get this MRI. And that's kind of, I don't want to call it a threat letter, but it's kind of like, hey, I'm going to put it on you. You're the one that's not doing anything, because work comp adjusters have a very heavy load. And you know what? They deal with what the loudest, squeakiest wheel. But a letter is very powerful. Phone calls and emails aren't letters. A letter becomes part of the patient's medical record, and that's where you want to go, is a letter. I think the last slide, if you go to the, is there another slide after?
There it is.
Yeah, back to the CME, but keep going. I want to go to the end because my phone number and my email and everything is on. Is on the last slide. If anybody has any questions, if you want anything that we talked about tonight, it's available. I'm also going to send the sample refusal of care form to Jen. So if anybody asks for that, they can get that. Again, it's a sample. You can have any questions. This is my number.
One final related to when you send that email to Jen, will you also share the zero tolerance statement that you gave in the earlier discussion? With the recommendation you had for staff to say we don't tolerate abuse and anything else like that. Somebody else requested that.
Yes, I will. And that might be a program next year of interest. I have a program I just developed, and it's called Dealing with Disruptive Patients and Documenting Their Behavior. And it's for physicians and for staff. And we can do it for CME. I have it for CME and for non-CME. So thank you. Thank you. Great hosting. Appreciate San Diego County Medical Society rocks, and have a wonderful holiday.